Welcome to Non-Obvious with Hugh Hansen.
We're very excited today, the whole team. This is our second podcast, and we're excited actually because Dave Kappos is here, but we're also in transition. We're in transition from name. It was going to be the Hansen Podcast, HCH, and now, thanks to some intervention of one of our research assistants, it's going to, I want you to tell me what you think of this. Not two words, not one word. Non-obvious with Hugh Hansen.
Like it.
Yeah.
Very nice.
All right, good. And so, Dave Kappos is one of these people that I think someone should check his DNA, because I'm sure there's probably some stuff there that isn't even human. All the stuff he's done over his life is like incredible, and he's been ridiculously successful, and it still is, and also a very nice guy. Tremendous combination. All right, so we're going to start off your life. You are a West Coast guy, correct?
Yes, born and raised.
All right, but you were Northern California, which is different than Southern California.
Well, I was born in Palos Verdes in Southern California and raised in the Huntington Beach area, Fountain Valley specifically. And my 95-year-old mother and father are still living in the home that I grew up in Fountain Valley, California.
All right, where is Fountain Valley?
It's basically a bedroom community in Orange County right next to Huntington Beach.
Okay, all right. But you went to school up north.
Right, undergraduate, UC Davis, law school, UC Berkeley.
Yeah, now, UC Davis, you were an engineer. So what was your major? What actually did you?
I was electrical and computer engineering in the days when that major focused on digital design, and before there was a CS major, so we got to take computer programming as well.
So to some extent with computers, you were computers before computers were cool. You and Dolly Parton, and that's what you said about country. You were ahead of your time of getting into, you graduated in 83, right?
Right, yeah. I started programming in 75 on a Burroughs machine when I was a sophomore in high school.
Wow. All right. So what drove you, or not drove you, but what interested you in the science or engineering or computer area? Was that just, you were born with that? You always knew you wanted to do that? Or did you think about various things to do and you picked that?
I enjoyed the challenge of solving technical problems, enjoyed thinking about computers and the promise of computers and the excitement of computers. And like you said, Hugh, in those days, they were not as ubiquitous and taken for granted as they are now. So there was fascination about the computer itself. Now, hardly anyone cares about the device.
Now, I saw someplace you were summa cum laude.
Undergraduate, yeah.
That's pretty impressive, isn't it?
I did okay.
Then you went directly, from what I read, into IBM. Is that correct?
Right. Yeah. I was recruited from Davis, and after graduation, I literally got on an airplane with what I had in a suitcase and flew to New York.
Now, at some point, though, this was 83 or 84, you started that. At some point, you decided to go to law school, which is not the normal road for somebody with your background and going to IBM. So what was it that caused, and did you go at evening or did you go?
I went in the daytime. Berkeley's an all-day law school.
But you worked at the same time or not?
Well, IBM had a really great program in those days, and so the company let me take a leave of absence each fall and winter to go to law school, and then I resumed my employment in the summer and worked part in engineering and part in law the first summer, and then I went back to Berkeley, took another leave of absence for my second year, And then after my second year, UC Berkeley was willing to let me go do my third year at George Washington in DC in order to get IP courses, because in those days, no other law school, at least none that I knew of, and certainly not Berkeley, offered IP courses.
And GW had one of the first major IP curriculums, and largely the result of patent examiners going in the evening to GW, and then GW just served that need and created a wonderful curriculum. How was your 1 year at GW?
It was great. I went at nighttime to GW in that last year and worked at the IBM Patent Law Training Center, which was located just walking distance from the patent office, then in Crystal City, Virginia. So it was like a perfect all IP all the time. I worked all day on patent applications, learning how to search, learning how to answer office actions, how to draft applications, how to draft claims, and then went over to law school and took literally every IP course they offered.
And how many did they offer?
Well, they had, those days, Don Banner was teaching patent law. I took him. Rennie Tegmeyer, you remember Rennie, right? Mm-hmm. He was teaching patent office practice, a very detailed course on 37 CFR and MPEP, basically. There was a copyright course. There was a trademark course.
Did you take them?
I took them all, yeah. And that might have been it in terms of the IP courses they had.
Yeah, well, most, and that was a lot. When I came to Fordham, and I didn't start out in IP, but when I started teaching IP, early 80s or something, we had 2 credit course in IP for everything. So obviously, and you basically had NYU, Columbia, Berkeley, GW, what else? John Marshall, and New Hampshire, and those were the sort of the centers for IP. So you spent your whole professional career before you became the director of the PTO at IBM. Now, most people switch around, or was that not the culture then? Or you just, what was it about IBM that it could, day after day, year after year or something, interest you in stuff with your inquiring mind and everything?
Yeah, I think so. A combination of things. One, it certainly was my philosophy to, choose something and stick with it. And so it was a natural for me. Number 2, IBM gave me a great career, just plain and simple. That it's a great company. It was, and it remains an institution. It's just a great company. And so it was a fun and challenging place to work with a culture of stewardship and a culture of institutional promise that really fit well for me. And then the third thing is they gave me a lot of opportunity. IBM invested huge amounts in training me in leadership, in management, in substantive intellectual property skills, and giving me jobs literally all over the world, one after another. So it was actually like having, 5 different jobs over a 26-year career, but you didn't have to change your badge. And
IBM, wasn't it called Big Blue or something?
Yeah, I think it still is.
Yeah. And it actually, there wasn't, today we think of trade associations and everything else, and basically IBM was by itself. And when the EU had its software directive, it was really basically IBM going over and representing, that area of trade, and no one else. It was one French company, and they were so dominant. But so what happens? I think they had, 60% even of the European market. What happened that IBM lost market share or other things to others? Is that just a natural progression?
Yeah, I think it is, Hugh. The market just keeps changing. And, IBM, I think, has been very smart in general about seeing market trends coming and moving its business. And that's what's enabled it to not only survive, but in general thrive over 100 years. So I remember when we sold the PC division, and I was heavily involved in doing the IP legal work for that and leading the IP team in doing that work. And it was, for me, loving PCs and, IBM being a leader in that field for a long time, at first it was a little difficult to think, God, we're getting out of the PC business. We created this whole business. But then you realize it's time, right? The market has moved. This is no longer a place for a company like IBM. And it was a brilliant move by Sam Palmisano, who made that decision and executed it. And it worked out extremely well for the company.
Did you ever think of going back to IBM after being director of the PTO?
Oh, sure. Yeah. I mean, it was, I never would have left had it not been for the PTO job. So I have, no reason not to.
All right, I was going to ask you this later. I might as well ask you now. So what was it about Cravath? I know they were a client, or they represented IBM. So you had some experience with them when you were at IBM, right, Cravath?
Yes, I had gotten to know through years of working with Cravath a number of partners and had lots of good relationships there. And, when I announced I was leaving the PTO, I connected with contacts at Cravath, and and it just went from there.
Okay, so you're now at Cravath. How did you end up director of the PTO? Tell us about sort of how that developed.
Well, it was not a job that I lobbied for or asked for or politicked for. I simply was called at the beginning of the first Obama administration by newly appointed Secretary of Commerce Gary Locke, and it actually was kind of a shock. I mean, my recollection of it was I was sitting in my office doing some work, answering emails or reviewing some document. I think it was a Thursday afternoon, and my secretary suddenly comes in and says, "The Secretary of Commerce is on the phone. Will you take the call?" And I said, "Well, I guess." And Secretary Locke said, "Look, I heard you can fix the patent office and it's in deep trouble. Will you come and do that?"
How deep a trouble was the patent office, PTO, at that time?
Well, it's all relative. I mean, I'm sure there are those who would say, it was no problem at all. But just if you look at the facts at that point in time, our country's economy was in free fall, and the patent office income upon which it depends for 100% of its operating expenses was in free fall because people stopped filing patent applications. So one of the things that I was confronted with, even before I was confirmed by the Senate, was potentially having to furlough the entire agency for the first time in its 200-year history. I mean, I was literally asked to help put together, I think they're called the warn letters, that you have to send to employees pre-furlough. And so we had to figure out a way to avoid doing that. We also, remember, had the TAFIS case. The first time in its history, the USPTO had been sued by its constituency to stop the agency from doing something that people felt so strongly about that they were actually willing to sue the USPTO.
What was it that they felt so strongly about?
That was the rule. Remember the rules package, the so-called claims and continuations rules package that was incredibly unpopular that had been proposed. So, the agency at the time, I think, was rated number something like maybe 178 out of around 200 agencies. So it was well into the bottom quartile in terms of the perception of the employees about the operations of the agency. So I thought things definitely were in rough shape.
And what year was this?
This was 2009.
Now, why were people no longer filing patent applications?
Well, because the economy was melting down.
2009,
Businesses,
yes,
right? Yeah, that was
yeah.
the bottom of the economic recession.
I see. And how long did it take you to say, I'm going to do it? Because it's obviously dramatic change.
Well, I had to talk to, if I recall correctly, two people. Most importantly, my wife, and then secondly, my boss. And, in both cases, I said, look, I'm willing to go do this, but I'm not going to do it if it's going to break glass. And my wife very quickly said, yeah, sure. We can manage it financially. Seems like an adventure. Let's go do it. And my boss, the general counsel of IBM at the time, Bob Weber, was extremely gracious also and said, look, your country asked you to go help. It's hard to say no.
Okay. And you were there for what, a little more than 3 years, almost 4 years?
Almost 4, yeah. I was confirmed in just before the August recess. I want to say the very end of July or early August in 2009, and I stayed until after the second inauguration, I think, to the 1st of February 2013.
Okay. And you were also, what, Assistant Secretary of Commerce or Deputy Secretary of Commerce for IP?
Yeah, it's Director of the USPTO, and what do they call it? It's not an assistant secretary.
Deputy?
There's a slightly different name that they give it. Undersecretary.
Undersecretary.
Yeah, Undersecretary of Commerce.
And what is that job, actually?
So that's the White House facing, administration facing, policy facing part of the job. And that's what distinguishes the USPTO leader role from many other patent offices. Like in many countries, the leader of the patent office has an administrative and management job processing patent applications, but has no policy role, does not speak to or for the administration or to Congress or to the courts on intellectual property policy issues. In the case of the U.S., the undersecretary part of the role is the policy part of the role. That's in the statute, right? It says that the undersecretary will advise the president through the Secretary of Commerce on intellectual property issues.
And how much free rein did you in that position have to determine what the policy should be?
So I felt that I was very lucky, actually, and I was given tremendous free rein. The government is a big enterprise, of course, and there are lots of constituencies. So for me, it was familiar. It was a little bit like IBM on a different, sort of a cycle. You had to learn who you needed to talk to and go have the discussions you needed to and build the constituency. So for me, there was a natural fit in doing the coordination I needed to do. I say that, Hugh, to say that I didn't go in there and just try and call all the shots on my own and say, I don't report to anybody. I'm the only guy who knows anything about IP in this government, and I'll tell you what to do. I approached it by seeking out allies and colleagues and constituents and working with them. And within that construct, I felt like I had enormous flexibility. I was able to do, essentially anything and everything I wanted to.
All right. Are we talking about domestic? Are we talking about also
global?
International?
Global. The treaties, remember the copyright treaties that Justin Hughes led, print disabled treaty, broadcasters' rights treaties. Those are the only treaties that have been done in generations, right? And we did them, and we did them readily. I don't mean that to denigrate Justin's work. He did absolutely fantastic work, and those treaties would have never gotten done would it not have been for Justin Hughes. But my point is, we were all over everything. The re-energizing the harmonization debate, we totally orchestrated that play on the back of the U.S. year of leadership of, what was it? One of the 20 largest economies, one of the big meetings that causes many other countries to be gathered, and the U.S. had that year to lead it. So we formed a play at the PTO. We said on the back of this big meeting, we're going to invite the chiefs of all the patent offices from the Asia Pacific region to come to the USPTO, and we're going to have a meeting on harmonization. And we're going to come out with an agreed statement that says that the Pacific Rim, the U.S. and everyone else in South and Central America and Asia, from Korea, Japan, on down to Australia and even I think India, we got everyone to show up, agrees that it's time to re-energize harmonization. And we took that, and it was all planned. We took that text.
So is
to
this
the European-
harmonization of the patent administrative process,
No, this was
or is
substantive
this all
harmonization.
substantive?
Yeah, this is grace period, right? This is the big stuff. This is full 18-month publication. Remember, at the time, the U.S. wasn't even on the first-to-file system. It was first-to-file, and we took on the responsibility to go get that done, and as you know, we did.
You know, it's not a big thing, but first to file was resisted by the so-called independent inventors. And in fact, I think the first Bush was ready to go that way, and then he pulled away because they said that corporations are going to end up stealing our stuff, and we don't know how to file, and America was really built on us, and this is sort of selling us out. Now, did you hear any of that?
Oh yeah. It was a huge issue. So the way we dealt with that issue was a combination of retail, and I can come back to that and explain what I mean by it. I'll give you an example, and rational policy. So we went and collected the data, something that folks forget to do a lot of times, but the PTO's got a lot of data. So we looked up for interferences that had occurred for, I want to say,
tell everybody what's an interference.
So an interference is when two parties invent the same thing and have the same claims pending in front of the agency. It's a little more complicated than that, but that's basically what an interference is. Two parties make the same invention at about the same time, and under the old regime, the USPTO would declare an interference, and it had an incredibly Byzantine, complicated process that took several years to figure out who's the real inventor. The most important interference that's been going on in recent years is the CRISPR-Cas9 interference between the Broad and UC Berkeley on who is the first and true inventor of that hugely important genome editing tool, CRISPR-Cas9. So anyway, we had to get first to file through, we had to understand and get the independent inventor community to understand how interferences really work. What happens when you live in a first to invent world? What does it really mean when two parties think they invented something at the same time and have this interference process? Because that's the only time it matters, right? If the party that's the first inventor is also the first to file, none of this stuff matters. It only matters when the paradigm little inventor guy makes an invention and doesn't file a patent application, and someone else comes in and files a patent application first. And then the little guy has to say, I invented that first, even though I filed second. We're going to have an interference because we invented the same thing. And the patent office is going to vindicate my rights because I invented it first. And you know what happened when we pulled the data? And like I said, we went back like at least 1 million patents. We went way back in time, as far as we reasonably could. We pulled all the data on the interferences and sorted them by interferences that involved a junior party who was a small entity versus a senior party who was a large entity, because that's the only time this matters. Again, if you become the junior party when you're the second to file. If the little guy was the first to file, they would have won under the first to file system, so none of it matters. It only matters when the little guy is a junior party. And you know what we found, Hugh? That out of all of the USPTO's records, when the little guy was the junior party, that party won the interference 0.00% of the time. There was not a single time they ever won. Couldn't find a case in the PTO's records. So I was able to go back and start explaining to members of Congress, look, this is all a false dichotomy. People that we really care about, small inventors, are being fooled into thinking that they have this system to rest on. I'll be able to vindicate my rights even if I'm the second to file, when in fact, they should put zero credibility in that because it never works for them. It never works. Senior parties have huge advantages in the interference system, and everybody knows that. So we were able to start then convincing and explaining this to members of Congress and showing them data that we need to have a more honest conversation. People need to know this current system doesn't work. and they'd be better off confronting the fact that they really need to be the first to file or they're not going to get the patent.
A little more on junior. Are they important anymore? Is there a role for the independent inventor today, or is it basically too sophisticated? And really the only people who can do this are larger organizations?
Well, so I believe the independent inventor remains extremely important. And while the proportions of patent applications filed by small entities and micro entities have gone down, the patent system remains the great leveler. It remains the great tool that enables the little guy to get a foothold. As much, I wouldn't say more now than ever, but as much now as it ever did.
Okay. Patent assertion entities, are they there to help? Do they help the little guy?
I think to some extent they do. They provide a liquidity opportunity for patents. So set aside abusive practices that happen by all kinds of parties, big ones, little ones, patent holders, and infringers who do all kinds of sharp things. So if you set aside abusive, the sort of, I'll say, the second standard deviation, the stuff off on the fringe where people do bad things, and you talk about legitimate inventor creates legitimate invention, gets legitimate patent, which I believe is what happens the large majority of the time, and then seeks liquidity event, which could be selling the patent to someone who will broker it to someone who is in a much better position to build a business around it. In my view, perfectly legitimate. And that's all a matter of specialization, which we've known for hundreds of years, is a great driver of economic efficiency.
All right, so the use of the word troll, is that legitimate or an intellectually dishonest way to have everyone thinking bad about one party when the facts actually don't support that?
I think it really is intellectually dishonest. I think it has gotten us into a huge, deep ditch in which we do things that are, in my view, frankly, very un-American and generally inappropriate of labeling. Parties should be judged by their behaviors and not have labels put on them. And the whole troll narrative has unfortunately badly distracted us from the real problems in the system.
Okay. You were a big party in producing and getting passed the American Invents Act. Isn't that correct?
Yeah, I certainly was heavily involved and did my best to help.
Is there anything looking back on that with either the substance or when it was passed or how it was passed or anything that you would do differently, or do you think actually, no, it was what we did was fine?
So that's a great question. I would tell you no, that there really wasn't anything that I would have done differently in any significant way. But Hugh, that's not to say that we did a perfect job. We now know that we wired the IPR system too tight. We were hell-bent, and I'll take the blame for this.
What's IPR system?
The inter-parties review, the post-grant challenge system that the USPTO now has. It was a very muscular system. It was designed to be very muscular. It was the answer to abusive patent practices. It was designed to do that. There's all over the House and Senate floor speeches. There was discussion about the post-grant challenge system stopping, quote, the patent trolls, right? So when the legislation passed, this was now the first, so everyone celebrates, right? Everyone backslapping. And then suddenly, I can remember this. I woke up, I think we had a big White House party, president, pictures in the Oval Office. It was great.
You actually have the pen that.
Yeah, I got one of the pens.
One of the pens,
yeah. And that Saturday morning, the next morning, I woke up and it suddenly occurred to me, and I turned to my wife and go, you know what? Who the hell's going to actually implement this? And I realized everyone else was gone now, and it was us at the patent office. It was our job to implement this legislation, 100% our job. Everyone was going to be watching us and frankly expecting the PTO to fail because that's the sort of expectation that people have about, frankly, about government generally, that it'll struggle to implement challenging new laws. And the other thing I realized was in the 200-year history of the USPTO, it had never before been given a precise time schedule to get anything done. The only place in 35 USC that had any time even mentioned before was the words, I think there's something like due dispatch that I believe go in the reexamination or reissue part of the statute. I think it's a reissue part. And so there was never any specific time given for the PTO to get its work done until now. And for the first time, we were told, you've got to get these things done in 18 months. Very clear, very specific. And so my instruction to the team was, we're going to design a process that will get finished every single time in 18 months or less. I remember very specifically telling the team at the PTO in our conference room there on the 10th floor of the Madison building that we were going to permit going over 18 months 0.0% of the time.
You're in this Madison room. Who are you telling? 5 people, 2 people, 100 people?
No, more like 15. We immediately assembled a team, a cross-functional team, because a lot of people need to be involved. Obviously, the board, but we had to create this new board. James Smith came in, who you know did a brilliant job of putting that together. The patents team, so the patents commissioner and deputy were there. The CFO, because you got to allocate money. The personnel head, Fred Steckler, because you're going to have to go out and hire like 100 judges. So I had all the right people in the room. We appointed a czar, Janet Gongolo, to be the.
But you also brought in some people from the outside to help you, right?
Sure, we started hiring judges immediately.
No, I'm talking about patent experts or patent people from academia or other places.
Yeah, so we did that. And we had those advisors in the room as well. Peter Manel was one of the Edison Scholar. We created a program called the Edison Scholar Program. Peter Manel was one. Jay Thomas from Georgetown was another one. I don't remember who others were. But we had a series of really great IP scholars, not just patent people, but IP experts come in and add their voice and add their scholarly external perspective.
And they were helpful?
Oh, extremely. I absolutely loved. I used to go into, Peter and Jay's office over on one of the side aisles of the 10th floor of Madison late in the evenings, 7:30 at night, and just sit down and just talk about issues.
And do you still do that with them, or are they? No.
Well, I mean, I don't work with them anymore.
No, I don't mean work with them, but I mean, do you call them up or any?
Not regularly. I mean, I see Jay, I see Peter at your conference, among other places.
What is, you might as well, what do you think is the best IP conference in the world, if not the universe?
Well, so I'm conflicted because I have been involved in the Fordham conference for a long time, but I will tell you, I really think it is the best. And the reason is because it is the only international conference anywhere. And I go to all of them. I go to tell you, I'll be in Singapore soon. I was in Japan last week. I'm at all of these things. The Fordham conference is the only one that authentically attracts for hard-hitting discussion. This isn't like speed dating to try and, get cases and win business. This is about IP discussions on a broad basis from all over the world. It's the only one.
Yeah, and you were going from way back when you were with IBM. And
oh yeah, I think now I've been at every one since 1999 or 2000 would be the latest.
Well, Megan knows we'll have to actually check that information here.
Yeah, you can fact check it, but I'm pretty
no,
sure.
I think you have been. All right, so who are the players now in just the U.S. IP? You got the Federal Circuit. You got you guys. Would you say academics are a player, or are they just an irritant on the outside now?
I think the academy is definitely a
Don't
player.
please don't
No.
say the academy.
Okay, academics I think are definitely a player, and probably more so than before. Because think about it, Hugh. The academics now are doing at least two things that I don't remember seeing really 20 years ago. One is filing amicus briefs. They file them all the time now, singly in groups, and those are some of the best amicus briefs, right? They're very carefully written, and they have no agenda except to get the law right. So that's one thing that they're doing that is like within the last 10 years, if not 5 years, has really come on. The other one is signing on to group letters, right? Letters into the administration, letters into the USPTO, letters to Congress that are expressing views in a very concerted and organized way. And I think that's great also. And then, of course, they do all the things that you guys always traditionally have done, which is write scholarly papers. There's plenty of that going on too.
Do you find that academics, with some exceptions, are generally more IP skeptics?
Yes, definitely.
And why is that?
Well, maybe you need to tell me on
I think
that
I know
one.
why.
I mean, I think there's a certain link to being property skeptics generally, and that then carries over to intellectual
Well, I
property.
think that's definitely true. But when I became an academic, before you were born, everyone who went into IP went because they were interested in, like copyright, for instance. They were wannabes, a wannabe singer, creator, novelist. Like I wanted to be a novelist. I unfortunately did not have any talent. And then we naturally went into copyright and science. The people who were interested in science naturally went into patents and were pro patents. Now what we have is, thanks to the internet and tech, the people who go into IP are from the tech side, and they view tech. The tech side views IP as the ghost in the machine. The tech can just beautifully distribute a gazillion things to everybody. Not with IP. It's just like international trade lawyers. They viewed IP as the problem because we want things to flow between countries, no barriers or anything else. Oops, you have IP. So those people, for various reasons, and antitrust people, they just view it IP as a monopoly, of course, which it isn't. But but it's much more. When I first started out, the interesting thing is the antitrust people were virulently anti-IP, the 9 no-nos and all that other stuff, and as were the international trade people. And so the General Agreement of Trade and Tariffs, which then became the WTO, the U.S. said, we want to put in a requirement that you treat IP. They went crazy on that. And then the U.S. got the EU to come in, and it was able to do it. But it was basically over the bodies of the people who had been pushing GATT and all those things over the years. But one of the things that happened is that these multinational companies had IP lawyers, trade lawyers, and they were pro-IP. So where you had these really different points of view, it became more mixed. And antitrust is another example. Look at the new Assistant Attorney General for Antitrust.
Yeah. Macon Delrahim has made some great moves in my view.
And but in academia, it's sort of the other way, whereas they were all for IP. Now a relatively small group are. It's interesting, but I think. I actually think academics have less influence than they did in the past.
Oh, really? Why?
Well, we'll see. Of course, my amicus briefs, and by the way, it's amicus. We're doing the classical Latin now, not amicus, but I think we're crucial in a couple of cases. And I have no proof of that, but of course. Anyway, all right, let's move on. So the Federal Circuit, where do you see them today as a player? Are they okay, mixed up? We don't know where they're going. What's going on with the Federal Circuit?
Well, I think they're, like the rest of us, they're struggling with the decisions coming from the Supreme Court to a fair extent, especially in the 101 area. And I think it's, to be honest, it's a mess. It continues to be a mess. The Federal Circuit is trying mightily, in my view, and making some headway, actually, in some of the recent decisions at trying to, recover from the mess that the Supreme Court has created and lend some framework, some predictability to 101 again. But I think the recent years of the Federal Circuit have been a lot about trying to sort out what's coming from the Supreme Court and to deal with that.
Well, yeah, I think one of the things is the Federal Circuit, which makes a lot of sense, wanted bright lines. So you could figure out, businesses had to figure out what we can do, what we can't do. And the Supreme Court was this, no, it has to be ad hoc, everything else and bright lines are wrong. And of course, what base are they doing that from? Maybe intellectual basis, maybe some other basis, maybe because they really don't understand it. And therefore, if you do it case by case, they can sort of figure out who's the bad guy in a case or something else. But it is not something that's going to be where you can then build on it if it's everything is case by case. And for years, there was no review of Federal Circuit decisions. 1 in 20 years or something like that. And all of a sudden, the Supreme Court is going this way, the Federal Circuit is going this way, and is almost looking at the Federal Circuit as a real problem. And so the review of the Federal Circuit now has made them probably paranoid or something, is that they really think everything they do is going to be watched by the Supreme Court, and maybe it is. But I think the result is you're not getting tremendous results from anybody.
So if you take that, Hugh, take your point into the agency whose job it is to execute on the laws, to implement the laws, it's chaos. When you try and tell 7,000, 7,500 examiners, all of whom come into the office to do a good job every day, when you tell them you've got to look at each invention and decide whether it's abstract, that's chaos. It's the paradigm of I know it when I see it. It's a personal decision. All these poor examiners, hundreds of thousands of times a year, now being tasked with making personal decisions. It makes no sense. It's not a repeatable process, as you say. It doesn't lend consistency. It doesn't enable businesses to make decisions. It drives senior business executives crazy, and it deprives the law of the respect and the understanding, the reverence that it deserves. When you go and tell a CEO, I really can't tell you whether your patent's valid or not. It depends on whether some folks think it's abstract. And the CEO walks away saying, I don't want to invest in this anymore. This system seems like it's just out of control.
But it's interesting. The Supreme Court likes it because they don't have to know anything. They just, how does it hit them?
Yeah,
I know it when I
it.
see it.
Yeah.
There's something wrong here, and we're going to do it. And actually, to their credit, to some degree, they were trying to limit their decisions. We're not trying to do this. We're not trying to do this. But the practical effect is different. Everyone's looking over their shoulder and all these other situations. And it's the extreme example, and maybe it works, is obscenity. Justice Stewart just said, I know it when I see it. We can't have a test. That may work for obscenity cases, but it's not going to work for the patent. All right. So director, Michelle Lee preceded you.
Succeeded, right?
Succeed.
That's
what did I say?
Yeah.
Preceded. Yeah. Succeed.
After Terry Ray, as deputy director, ran the place for, I want to say a year or so.
And to some extent, everything was going well. You have this great machine working and everything else. And then you run off to Cravath, leave everybody in the lurch. And what we have is, and then the president engaged or whatever for years, how many years or months or years did he take to actually appoint a replacement?
Yeah, it took a long time. Yeah. It took a long time, like 2 years.
And a lot of people weren't keen on the replacement. So what happened there? I mean, it's like everything is going well, and then boom, you leave, and it just all falls apart. Is anyone at fault for this, or is it just the way nature the things happen?
Well, so I would disagree with the sort of premise. I don't think it's fallen apart. I think there was a lot that was done that needed to be done to implement the AIA. That was really the project for the second administration. It was a huge piece of legislation, a lot involved in implementing it. And the team, I think it's fair to say for the most part, has done a really good job in implementing it in lots and lots of ways that it doesn't get anywhere near enough credit for. So I think that was going on and went just fine. I think also there was the overlay of the Supreme Court decisions on 101, which created a chaotic situation.
Now, all right, let me ask you this. If you were still there, I mean, you implement. If you were still there, you would have tried to make sense out of all this thing, and maybe the rules you would have given to your examiners or other things might have been different. Is that true?
Well, yes. And you can fact check this one with my good friend Bob Stoll, who was my commissioner for patents most of the time when I was at the PTO. And Bob and I are in constant contact. We were together in Tokyo just last week. When the Alice decision came out, I believe that's the one. The morning of the Alice decision, we both read it, and we sent each other either emails or got on the phone or whatever, and immediately said, this is perfectly okay. Just look at the line. It was Justice Thomas, right? Look at the line that says this decision should be read narrowly, lest its holding swallows up the Patent Act. And we said, that's the line. What the agency needs to do is put out a memo to examiners today and publish it that says, steady as she goes, great Supreme Court decision. They just came down and said, we meant what we said in Bilski. This is very narrow. Keep doing what you're doing. And that was both of our immediate instinct. And I think had that happened, things would have, I think, probably gone differently. And you would have gotten, Hugh, what you rightly pointed out a few minutes ago is seeing that the Supreme Court has been trying to render extremely narrow decisions, interpreting them narrowly, and continuing on with the course.
Yeah, I mean, basically they gave, when they did not want to rock the boat, they would bring in Thomas. But one time they brought in Breyer, and Breyer has very strong views and everything else. And even though he said, we're not doing this, we're not doing that, but we're doing that. And you read that opinion, there's enough in there for people to go all over the lot. But I do think that if you had stayed in there, that we would have had a much better post the situation today. And I don't think there were the votes to come down hard on doing things a little bit different, but not dramatically different. But then when you have the Federal Circuit, and in banking, I can't agree. They're like 6-5 or something else and all these other things. And then you had that period of bad patents, which spooked a lot of people. The court said, okay, we can't trust the Federal Circuit now, and we have to sort of continue to take cases and continue to take them. And I thought it could have been, okay, we did it, we're moving on. But not moving on has been a serious problem.
Right, it's been sort of one after another.
All right. So who are we going to... Are there any justices of the Supreme Court, do you think, okay, that's a safe pair of hands, or they all sort of, they really don't know it, they know they don't know it, and what?
Well, so I like the decision on international exhaustion, or not international, on international damages that came out.
That just came out, yeah.
Yeah, so I think you look to that for a recognition that patents matter, patent damages matter, and I don't know whether that marks the beginning of a trend. Now the court's going to look at another thing that we worked hard on in the AIA, which is the on-sale bar and secret sales and whether they count as prior art. That's going to be a challenging case for them. But you hope that the logic that was used in this decision that just came out on damages would prevail.
Yeah, and that certainly actually may help patent owners in settlements and other things.
Oh, sure. Yeah, it definitely will.
All right, let me look at some of the things that have come in. I'm not going to mention people's names, but all right. One is, why isn't international arbitration a much better way to go in this world where you can't tell what's going to happen? And people aren't crazy about the Court of Justice either when it comes to patents. So one person is questioning, you have international arbitration and usually have people who are going to be picked to have some knowledge, or they're not going to be picked in the area. And you'd have more certainty, more predictability, less expensive. Why aren't more people going to that?
Well, so I think that's actually a great idea, particularly in these complex global licensing situations like we're involved with standard essential patents. And we've seen decisions, including the great decision by Justice Bierce in the UK, that starts to work on this concept of what is a global license anyway, and how does a court in one country determine a global FRAND licensing rate. And I think, Hugh, the concept of international arbitration is born of cases like that, where people look at them and they say, this is really hard. And Justice Bierce, in his case, had to write whatever it was, I think it was around 160-page opinion or so. It was incredibly detailed. I'm sure it took an enormous amount of time and intellectual energy. You can't just repeat that for every time after time there's a new case. It's much better to get a panel of arbitrators together and do an international arbitration. And I should tell you, that's coming together. In fact, this week, almost as we speak in Tokyo, there's an inaugural meeting going on of a new international FRAND royalty arbitration center that's being stood up. The two new international, the judges that are included in it are from all over the world. I believe Australia, Europe, including the UK, Germany, and at least that I know of, if not other countries as well. Of course, Korea's in there. I believe multiple judges from China, Japan, the US, and we're going to see this international arbitration center stand up to judge these kinds of situations, that is global royalty rates, especially for FRAND. And I congratulate the JPO and Commissioner Munakata-san for leading in creating that kind of thinking and standing up that center. So we'll see if it succeeds, but I think it's a great idea if it can be balanced and if it can stand up to the interests of the many implementers who want to drive value out of the patent system in order to take their costs down, and if it can appropriately identify damages and royalty rates that compensate innovators for the huge sacrifices and the risks that they take. I think if it could do that, it'll be quite a success.
All right, part of this is a question. Part of this one is me. So to some extent, in the world of litigation, a large multinational suing in a smaller country, regardless of what the law is, a treaty or something else, there's going to be pushback sometimes by the smaller country judges. One is because they had nothing to do with the law; it came in through treaties, so they didn't. The legislature and nothing else, so it's just being imposed on them. Two, though, it's multinationals against small. And three, if it's an American multinational, for a while there was a lot of anti-American and sort of dissipated. But now with Trump, can we expect more of this just the Americans suing in a country and this is the question from the person who wrote in, there'll be pushback just because of Trump trade wars and other things.
Yeah, I don't know. That's a great question. If I were advising a global company on filing a case right now, depending on where, I certainly would be factoring that into my decision. But I think, to be fair, Hugh, for most cases, they're going to be under the radar screen. It would be the bigger cases, the ones that have higher stakes and are more political, particularly in small countries, where you'd need to factor that political component in.
Okay. Do you give, by the way, do you give advice on to clients as where they should sue? Is that part of what you do?
Yes, in the sense of, I don't like getting in disputes. I almost always find myself advising clients, don't get involved in litigation if you can avoid it.
So settlement is a better proposition.
Yeah, or finding ways to form alliances and agreements. And one of the things I've always loved about Cravath is that the philosophy there is very much of a careful one for clients. So, but I do get called in and am advising on a number of those kinds of situations right now.
All right, all right, I'm looking at these now. There might be some U.S. Unilaterally doing things in administration. This is applied to IP. To what extent does it undercut common ground with other countries? I suppose that's in there too.
Yeah, unfortunately, it does, right? To see, for instance, the U.S. for many years has, this probably, Hugh, as well as I do, it's all over our treaty history that we told other countries we absolutely would forbid international exhaustion, that exhaustion had to be on a nation-by-nation basis. And then to have the U.S. Supreme Court just go and totally undercut USTR, all of our treaties, all the negotiations that have gone on, we look silly around the world.
That was one of the worst decisions I think they've ever had. And of course, they did not listen to my amicus brief. But and it was just incredible because actually in a previous decision, Stevens and Dicta said there was still no international exhaustion. So everyone has been going for years and years and years that it is, and you can now rely on Stevens' dicta, and then they do that. Now, that was one of these split decisions where you had dissenters, and two of the judges who went along with Roberts on this said, well, actually, we probably don't agree, but we think that previous Stevens case requires this, which is crazy because he actually said right in it, it doesn't require it. So, and it was, you would think if they're going to do something like that, they'd wait till they can get an outstanding majority, true majority to do it. And that's one of the problems with our Supreme Court, I think, is one is they're not necessarily knowledgeable, certainly of industry and the effect in the real world, and they're arrogant, and they know better. And that's not really what you're looking for in your Supreme Court, but that's what we have. All right. Antitrust and IP. Is it going in the right direction? Which I think it probably is right now, but I'll leave what you say. The thing is actually they're not contradictory. One establishes certain rights and others looking for abusive behavior, and they both can be put together and work out okay. But what you have then is people who, NGOs or others or techies who want to use it as a tool to broadly limit IP. And then you have others in antitrust who are trying to make it actually rule of reason more reasonable with regard to various business practices. So what is the future of antitrust and IP? Is it going to be better, going to be worse, conflict? We don't know for sure. What?
Well, so first of all, Hugh, I would agree with you that it's definitely getting better in the U.S. The new administration has come in and said several things that I think are noteworthy and very positive. Number one, we want to see data. We are going to guide our antitrust enforcement and policy based on data. That's great, and it's really important, and it's a long time overdue. And then the second thing they've said is that we like innovators. And they've said basically, Hugh, what you're saying, that antitrust isn't about being against intellectual property. In fact, it recognizes that the dynamic competition brought on by intellectual property and the disruptive change enabled by intellectual property is really positive for competition. So there's this second item of the Department of Justice in particular now taking a longer term view of competition and the needs to have investment in building new business paradigms, which requires in turn strong intellectual property. That is a really positive trend. But the other thing, Hugh, that you didn't mention, and I think needs to be talked about, is the international component. So, 35 years ago when I was starting to do this stuff, there were basically two antitrust regimes, the U.S. antitrust regime and the European antitrust regime. And they were basically more or less, aligned with modest departures from time to time. Now we have, I forget the exact count, but it's at least 130 or more antitrust regimes. Every big country, every medium-sized country, every small country, and even most of the really small countries have antitrust regimes. And the problem with that is that each one of them is addressing and pursuing its own national agenda. Now, even in the case where that national agenda is based on the law and administration and enforcement of the law, even there you get very suboptimal results. I see this in the big deals we do because you can have a deal that affects 100 countries. And if any one of those countries, maybe 20, 30 of those countries, has some issue with potentially losing a local competitor or what they perceive to be a local competitor in their market, they will block the deal or extract something from the deal that will then disadvantage competition globally. So there's a tremendous friction there, even in those situations where it's all, enforcement of the law and there's no other agenda at play. The second problem, even bigger, is that the antitrust laws are inherently very malleable. They are very general in nature. They're nowhere near as specific as the patent laws. And in the hands of enforcers who have a national agenda that they're pursuing, a national competitiveness agenda for their particular country, or an anti-foreign multinational agenda, or we're going to help the local competitors, our national champion agenda, whatever that is, it's got nothing to do with advantaging competition for the benefit of consumers, and it's got everything to do with other agendas. The antitrust laws are a perfect tool in the hands of those enforcers, and they're being used that way. And so you're winding up with, antitrust chaos all over the world, and harm being done to consumers on both a national and a global level.
Yeah, well, basically, it's a tool of industrial policy now, whatever that is. And a country you were just in it talking about, China, is probably the prime example of that. And they have this story, which, of course, EU went after Microsoft, right? And a very famous decision and close. And in fact, the court of first instance only affirmed it like 7-6 or 8-7, which is very unusual. It's peculiar and probably doesn't carry much water, but it was a strong decision against Microsoft, which actually in the U.S. was not taken. So then this person who ran that litigation in DG Comp, or I don't want to get too much into names, but he was talking to me about it, and afterwards, the head of competition in China came up to him and said, well, what did the U.S. do to you after that? Meaning the government. He said, what do you mean, what did the U.S. do to us?
Do anything.
We're independent. He said, well, if you had done that, what you did to Microsoft to one of ours, I would have been told to go after two of your companies in even a worse manner to teach you a lesson. Now that's very frank, and this was two heads basically talking to each other. And that's sort of what is going on to some degree. And it's so you have the small guy just want to protect the local. You have China, which is we want to protect our stars as against anyone else. They're not small and not weak, but we want to be able to. So you have, I think you're right. You have a situation which it can be pretty grim. So what can be done about that, if anything?
Well, I'll tell you what needs to be done. Number one is U.S. leadership, and it starts at home. The U.S. antitrust agencies, the DOJ and the FTC, and to the credit of making Delaware, the DOJ is making the right moves, need to clean up their own house, and they need to stop the agenda-driven enforcement and the discriminatory enforcement. And I'll give you another example that I'm sure you're aware of, Hugh, you'll love. What I thought was that totally irresponsible position that DOJ antitrust put out against the fractional licensing of copyright interests in the music industry. It was atrocious, and it was clearly agenda-driven. And I was so happy that the Southern District of New York hammered it, and the Second Circuit hammered it for what it was. Stop it with that, right? That's irresponsible. And to the credit of the DOJ, they are. I hope the FTC will get on board with them and first clean up our own shop, and then start going out, as the DOJ is already doing, overseas, and sending new messages that say, look, we're settling this down, and you need to do it too, and we're going to be expecting you in your country to do evidence-based antitrust work and not be pursuing national industrial policies or just advantaging the interests of local champions.
What was scary about that case is, one, is there were good people involved in it. Two, it was so stupid, it was unbelievable. We're talking about consent judgments that have existed since the 1940s.
Right.
And the antitrust division is saying we're unilaterally changing those, which you can't in a consent judgment.
Silly.
And there is a consent judge who will hear everything that happens with regard to that. Set up basically so that one of the two, BMI or ASCAP, if they're asking too much, a consumer company can go to this judge and say, look, they're raping us on this charge. We want a lower charge. That's why it was created. But that person's going to hear everything. And it was 2 seconds. Right. Not in a short opinion, this is ridiculous.
Right.
And that was scary, I have to say, because it was no chance of succeeding.
Right.
And I thought, they had some good people then in the antitrust division. So you're right. I think we have to start at home with this, but we are now, right?
Right. Yeah, it's much better situation.
All right. Now, if you were me, and
no one is Hugh Hansen.
I don't mean to scare you by that. What would you ask you?
Well, let's see. I would ask about new technology trends that are having and will have a huge impact on intellectual property. The first and foremost is blockchain. I think that nowadays you need to talk about blockchain.
What is that? Give us a definition.
I'll give you a definition. You don't have to be a technical person to understand blockchain. Blockchain delivers that uniquely human attribute and quality that is perhaps the most valued and rare thing on the planet: trust. Blockchain is simply about trust. And if you can deliver trust, you've got something really special. That's what blockchain is.
Well, how do you deliver trust? What is the mechanism?
So blockchain delivers trust through consensus, through broad consensus that is not controlled by any one party. It's a brilliant basic concept that says, in a world in which I either can't or don't want to trust any particular party, whether it's a government or a company or a person, how do I gain trust? Well, I gain trust through consensus, through consulting with many others and finding out that they agree on a certain state of affairs, on a certain thing. And so blockchain establishes trust through consensus.
And what's the future of that? What's going on?
So there are huge. So first of all, Hugh, I would tell you, it's not about speculating on cryptocurrency. That's the tail, not the dog. That's little stuff. Kids thinking they're going to get rich, and the vast majority of them don't get rich. That's not what blockchain is about. Blockchain enables business transformation on a very, very broad scale. So, for example, as blockchain gets up and working more, we are going to have the ability to walk into a drugstore and with our smartphone scan essentially the two-dimensional barcode on a product in the drugstore and immediately learn whether it is genuine, whether it is authentic, whether it has any problem with it, like a recall that's may come about or has come about, whether it in some other way became adulterated, such as that it wound up, it should be refrigerated and it was sitting in an unrefrigerated environment for a day, something like that. So think about the impact of that. First of all, you've got much better supply chain control. Second of all, in our domain, intellectual property, right? So supply chain control means safety, means consumer happiness, means companies don't have to go find all their bad products and spend all the money doing that. So it's good in lots of consumer ways. But if you think about the intellectual property connection of this, first of all, you totally change the way you think about trademarks in a lot of domains because the brand is established by the blockchain. That's what lets you know that this product is authentic. Trademarks will still be around and they'll still be important. So I'm not saying trademarks will go away, but blockchain will play a role that will supplement the trademark. So that's, in my view, quite fundamental. Second thing that's fundamental in the intellectual property domain about this, as you have the blockchain working, you can police counterfeits, right? You can take counterfeits out of the marketplace much more readily. Go to another domain. I was just talking about pharmaceutical and healthcare products and drugstores. How about music? Music will be all blockchain enabled, which will mean, when a piece of music is traveling around on the internet, it will then interact through the blockchain with the media that play it, no one has DVD players anymore, but I guess the download that will occur in your home or apartment, and the piece of content will only work then if it is solid on the blockchain, and the blockchain can confirm that it was paid for content. So you're going to see in the content domain movies, right? So cinematic films that are distributed in all the forms they get distributed now, music, et cetera. Blockchain-enabled distribution channels that will be much more robust to piracy. So you see there another huge benefit at the intersection with intellectual property.
It's almost too good to be true. So what has to happen for this to happen?
Well, there are a lot of things that are taking place and that still need to take place. What's going on now that I'm seeing is a lot of pilots, right? Blockchain pilots. Everyone's doing them. And that's great, and that's a start. So those are going to then have to transition to scaling up, which will take a number of years. Blockchain has a lot of good things going for it, but one thing that's challenging, it is very compute intensive. It takes lots of IT resources. So there will be a period of transition when we move from pilots to scaling up these technologies. And then you've got an adoption curve, right? Because not everyone's going to be able to get on board at the same time. So there's a lot. But think of blockchain in another way, and I'll make it personal in the sense that, I remember starting to use the internet in around 1992 or something like that. Mm-hmm. So pretty early days, and realizing very quickly, this is when, we were all enthralled with the Netscape browser and stuff like that. Realizing this is big, this is really big, and it'll take a while to play out, but it's definitely big. The blockchain represents the second instance of that in my career. Second thing I've seen where I've said, oh boy, this is really big. And one of the reasons is because of what I told you before. It's really just about trust. The other reason, put a little more technically, blockchain is the security layer for the internet. When the internet was designed, an affirmative decision was made not to put in a security layer. And we've sort of labored with that problem about the internet from day one. And a lot has been done to try and somehow superimpose security over this wonderful technical mechanism, the internet, that has no security inherently in it. Blockchain is the security layer for the internet. So it totally, over time, it totally transforms the internet into a tool that can have security built in.
With that, I think we're going to end our second podcast and thank Dave Kappos for being our guest and a wonderful guest. And lots of luck with all you do now. We'll be following you.
Okay, I'm writing. I'm working on a couple of papers right now. So I'll be continuing to try and be a voice for strong, balanced, and appropriate IP rights globally.
In one of those papers, you're going to just have a footnote saying the best conference in the world, if not the universe, is the Fordham IP conference, and I appreciate that. Thanks again, David. It was great having you
My
here.
pleasure. My
Okay.
pleasure.
Bye-bye.
Yep, bye.
Thanks for listening to this episode of Non-Obvious. You can subscribe to us on SoundCloud, Apple Podcasts, or Google Play, or visit our website at nonobviouspodcast.com. Now here's a short preview of our next episode, where we'll hear the second part of our interview with David Kappos. Are there any drawbacks to a strong patent system?
Oh, yeah, of course. I mean, we saw that as you say, towards the turn of the century and after the internet bubble burst, and tens of thousands of, really not very strong, very weak, actually, software, internet, and business method related patents were unleashed, untethered into the world. And it led to this run-up of abusive litigation. And that was not good for our country or for innovation or for consumers or for anything. So I think that was an example for us of a patent system that had become too easy to abuse.